Hi, I'm Dominic. I work as a staff attorney with Legal Aid of Northwest Texas in the Denton office. I'm here remotely with Becky Mosley, an attorney in our Community Lawyering Center in Dallas. Becky handles many types of cases with a focus on housing law. So I wanted to ask her some questions and get some answers about rent payments and evictions in Texas during the coronavirus pandemic. Becky, can my landlord just kick me out of my home?
Hi, Dominic. No, your landlord cannot evict you from your home without going to court first and getting a court order making you leave. A self-help eviction, where a landlord forces you out or throws all your belongings out without a court order, is not allowed under Texas law. And we can talk about how a landlord might get that order later in the conversation.
All right. So I thought the court said I can't be evicted right now. Is that true?
There have been emergency orders from the Supreme Court of Texas in response to the coronavirus pandemic. One of these orders from March 19th pressed pause on most evictions in Texas. The order says that until April 19th, a court cannot order an eviction or enter that eviction order in most cases. It's also possible that your county or your local courts might have delayed evictions even longer than April 19th. So you should check with your local court to find out if there's any additional extension that applies to you.
So what types of evictions, if any, could happen before April 19th?
You can be evicted if you or someone you live with is involved in criminal activity, or you or someone you live with poses an immediate threat of physical harm to other tenants or to the landlord. These evictions are allowed to go on and be heard even during this time. But evictions based on not paying rent or other reasons cannot go forward until after April 19th.
Does this mean I don't have to pay rent for April?
No, you must still pay rent. The Supreme Court emergency order does not change your responsibility to pay the total amount of rent to your landlord on time.
Now, what if I'm staying in an extended stay hotel? Does all of that still apply to me?
It might. It's possible that a person living in an extended stay arrangement may be able to be considered a tenant. Generally, people who are staying in a hotel are not considered to be tenants, so they do not have the same protections in the law as someone renting a house or apartment. Also, the Supreme Court order that we're talking about only delays the eviction of people who are considered tenants.
Can I talk to my landlord and see if they'd be willing to work with me?
Yes, you can. It is possible that your landlord is willing to accept rent late for April after April 1st. If the landlord agrees to do this, or if there are any agreements between you and the landlord, either about when rent is due or the amount of rent, you need to get the agreement in writing from the landlord. If you do not, and you do not pay the full amount of rent on time, you put yourself at great risk of being evicted.
So what happens if my landlord doesn't want to work with me?
Your landlord may give you a notice to vacate, which is the first step she must take before filing an eviction lawsuit. That notice demands you leave your home or apartment and move your things out. If you get a notice to vacate, you have a choice. You can either move out like the notice says or stay in the unit. If you stay, your landlord can file an eviction lawsuit at the local justice court to try to have you evicted by the court. I want you to know that even under the current Supreme Court order, your landlord could still take those actions now. However, the court process for the eviction lawsuit is paused until April 19th.
So what happens after April 19th if I can't or I don't pay my rent for the month of April?
After the Supreme Court order ends, we expect the normal process will begin again. Like I mentioned, a notice to vacate is the first document you might receive when a landlord wants to start the legal eviction process. And if you do not leave, the landlord can file a lawsuit against you. After a landlord files an eviction lawsuit, you will be served with court papers. Again, under the March 19th order from the Supreme Court, this service of papers is delayed until April 19th, except for cases of criminal activity or harm. If you are served with court papers, they will include the landlord's lawsuit, sometimes called a petition. And that explains why exactly the landlord wants to evict you. The papers also include instructions. You will need to follow the instructions carefully to make sure the judge can hear your side of the story. If you do not follow the instructions, especially to appear in court at the right time, your landlord could get what is called a default judgment against you. That means that the landlord wins without the court hearing your side. If you do lose at a hearing, you have 5 days to appeal the eviction order, also called a judgment, to the county court. And those 5 days include weekends, so it's a very short time. And the last thing I'll note, if you lose your hearing and you get this eviction order, and then you do not appeal that on time or move out before the appeal is due, that's when a court can issue what's called a writ of possession. That order tells the constable to make you leave the property and remove all your belongings outside. The Supreme Court order we discussed has postponed a constable being able to do this until April 26th.
And what if the coronavirus pandemic lasts longer than April 19th, or if I'm still required to stay at home?
It's possible that the Supreme Court could issue another order that extends the April 19th date, in effect pressing pause on evictions for a longer time period. However, as of now, the current order issued on March 19th allows the eviction process to start again after April 19th and allows those writs of possession to be carried out by the constable after April 26th.
Well, thank you so much for joining me, Becky. If you do have more questions or if you need legal assistance, you can apply for help at your local legal aid office. Legal Aid of Northwest Texas provides free legal help in areas like housing, consumer law, public benefits, and family law to low-income individuals and families in North and West Texas. If you live in North or West Texas, you can apply for help with Legal Aid of Northwest Texas, and eligible applicants can speak with an attorney. You can apply by either calling 888-529-5277, or for housing problems and most other types of civil legal issues, you can apply for help with us online at internet.landwt.org.